Hey y'all, how's it going? It's David with I'm So Offended. Uh, we're gonna get into some of the hearings regarding child support and the kind of paperwork that people get. And as always, um, I'm not an attorney. I'm not an attorney. I don't practice law. I'm not a lawyer, and I don't pretend to be. I'm not liable for anything you do. Um, All this information is for educational and entertainment purposes only, and you do whatever you want to do. Um, but let's get into something that when you get that child support contempt proceeding, there's several different ways in which it might look like, and here's one of them. It'll look like this. It'll look like a motion for contempt and notice of hearing, right? So that's when I guess you haven't been paying the child support or the full amount or whatever it may be, but this is when the state is involved. All right, so we'll look at one of these here. So here's a case, right? It says motion for contempt, notice of hearing. You're hereby notified, State of Florida Department of Revenue, and on behalf of the petitioner, which is the state, right, shall apply for an order adjudging the respondent to be in contempt of this court's previous order by failure to pay child support or re-reduce alimony or to provide medical coverage as ordered. Additionally, the respondent should be responsible for all costs and fees of this proceeding. So they're suing you, and they're saying that you're responsible for for them suing you. Oh my god. All right. Date and time. The above date and time is your opportunity to present evidence regarding your failure. Listen to this. The above date and time is your opportunity to present evidence regarding your failure to comply with the previous court's order. You're already guilty. Read this again. The above date and time is your opportunity to present evidence regarding your failure. It's not present evidence regarding your defense or regarding um, your alleged failure, or no, you're already guilty. You're already guilty. Okay? You're already guilty. That's what it says regarding your failure to comply with the court's previous order. So, if you fail to appear as directed, this matter shall be decided by the child support hearing officer, magistrate, or judge sitting in as child support hearing officer in your absence. You are strongly urged to prepare and file a Florida Family Law Rules of Civil Procedure financial affidavit prior to the hearing, as I underlined this here. Your ability to pay is a critical issue in this contempt proceeding. All right. You'll be provided an opportunity at the hearing to respond to the allegations and questions about your present financial status. All right. So then it says in bold, failure to appear at the hearing may result in the court issuing a writ of bodily attachment for your arrest. You may be held in jail for up to 48 hours before a hearing is held concerning whether you have the present ability to pay support. And if so, whether the failure to pay was willful. All right, and then it goes on to say, let me get this a little smaller so we can see it. Should you wish to seek review of the order upon the recommendations of the child support enforcement hearing, blah, blah. All right. So we saw what it says. So let's say you get one of these. What do you do? What do you do? What do you do? Right? All right. Where are we? State of Florida. It says up top, right? State of Florida. Okay. What is the title of this? Motion for contempt and notice of hearing. All right, that's what this is called. All right, so let's look this up. And all I did, Florida Family Laws, Rules of Procedure, Motion for Contempt. That's what we have, right? Let's look. Florida Rules. It's telling us to look at, where is it? Down at the bottom, right here, in the middle there. Florida Family Law Rules of Procedure. Okay, so this is what we're doing. They're telling you this is what we're doing. This is what they're using these rules under. This is where the motion of contempt and notice of hearing is coming from. Florida Family Law Rules of Procedure. Okay, all right, let's look that up. Here we go. Florida Family Law Rules of Procedure, motion for contempt. Okay, all right, it's right there. Comes up right at the top. Here we go. There it is. All right, what's it say here? This rule governs civil contempt. In support matters related to family law cases, the use of civil contempt sanctions under this rule shall be limited to those used to compel compliance with the court order or to compensate a movement for losses sustained as a result of the contemptor's willful failure to comply with the court order. Contempt sanctions intended to punish an officer or to vindicate the authority of the court are criminal in nature and are governed by Florida rules of criminal procedure. Okay, so motion and notice. This is the procedure that they need to follow. Civil contempt may be initiated by motion. The motion must recite the essential facts constituting the acts alleged to be contemptuous. No civil contempt may be imposed without notice to the alleged contemptor and without providing the alleged contemptor with an opportunity to be heard. The civil contempt motion and notice of hearing may be served in accordance with rules of practice and procedural administration, provided notice is reasonably calculated to apprise the alleged contemptor of the pendency of the proceedings. This notice must specify the time and place of the hearing and contain the following language. Okay, let's where's our document? Right there. Time and date, location of procedure. Okay, what else? Failure to appear at the hearing may result in the court issuing a writ of bodily attachment. If you're arrested, you may be held in jail for 48 hours before a hearing is held. Do we have that? Yes, it's right there in bold. Okay, so they're following the rules. This is what they're doing. They're following the rules, right? Okay. Now the hearing. This is how it must be conducted. In any civil contempt hearing, after the court makes an express finding the alleged contemptor had notice of the motion and hearing, court shall determine whether the movement has established that a prior order directing payment of support was entered and that the alleged contemptor has failed to pay all or part of the support. So they need all of these things to happen, right? Number one and number two, the court finds the movement has established all the requirements in the subdivision C1, what we just read. Then, if the alleged contemptor is present, determine whether the alleged contemptor had the present ability to pay support and willfully failed to pay such support. B is if the alleged contemptor fails to appear. Set a reasonable purge amount based on individual circumstances of the parties. Court may issue a writ of bodily attachment. Direct that upon execution of the writ of bodily attachment, the alleged contemptor be brought before the court within 48 hours for a hearing on whether the alleged contemptor has the present ability to pay support, and if so, whether the failure to pay such support is willful. All right. Order and sanctions. After the hearing, the testimony and evidence presented, the court shall enter a written order granting or denying the motion for contempt. Here we go. An order finding the alleged contemptor to be in contempt shall contain a finding that a prior order was entered and prior order was entered, previous order failed to pay child support. Okay, we have a prior order that The alleged contemptor has failed to pay part or all of the support entered. Okay. Previous order. And so this is what they're alleging here. And they already say that you're guilty because it says here regarding your failure to comply with the previous order. Okay, so they got that taken care of. And then what do we have? That the alleged contemptor had the present ability to pay support, and that alleged contemptor willfully failed to comply with the prior court order. The order shall contain a recital of the facts of these findings. Hold on, I'm getting ahead of myself. The order shall contain a recital of the facts on which these findings are based. Now, if the court grants the motion for contempt, the court may impose the appropriate sanctions to obtain compliance with the order, including incarceration, attorney's fees, suit money, compensatory, look at this, or coercive fines. They're not even hiding it. They know what they're doing is coercion. Okay? And any other coercive sanction or relief permitted by law provided by the order includes a purge supervision. All right, so here's the purge. If the court orders incarceration, a coercive fine, or any other coercive sanction for failure to comply with a prior support order, the court shall set conditions for purge of the contempt based on the contemptor's present ability to comply. The court shall include its order separate affirmative finding that contemptor has the present ability to comply with the purge and the factual basis for that finding. All right, let's skip down to the court may issue a body attachment. Upon incarceration, the contemptor must be brought before the court within 48 hours for a determination of whether the contemptor continues to have the present ability to pay the purge. All right. So 48 hours, right? So let's say you defend your rights and and they still issue the body attachment, all right? Because I know guys that this had them happen to them, but it says within 48 hours, right? Because almost anybody could be held for like whatever reason for 48 hours, right? And then they have to be let loose. They got to charge you with the crime. They got to, you know what I mean? Unless a crime is severe, and then you have bond, especially if you're talking about a criminal matter, right? Okay, 48 hours. That's when they're going to check if you have the present ability to pay the purge, right? So it's review after incarceration, notwithstanding the provisions of this rule. At any time after a contemptor is incarcerated, the court on its own motion or motion of any party may review the contemptor's present ability to comply with the purge condition and the duration of incarceration and modify any prior orders. So where there's a failure to pay support or to pay support on a timely basis, but the failure is not willful, nothing in this rule shall be construed as precluding the court from granting such relief as may be appropriate under the circumstances. So, they want financial information. They want, they can only state that you're doing it willfully, right? They have to prove it. So, how are they going to prove it? How are they going to prove that you have money? Are you going to tell them? There are rules. So when you file your response to a document like this, to a motion for contempt, all you have to do is look up their rules and it's simple. They need to find that the alleged contemptor had the present ability to pay support. And they want you to give them evidence to use against you. Are you going to do that? No. No. The most they can do is incarcerate you for 2 days, and it's over. They have to prove that it was willful. They have to prove the contemptor's present ability to comply with the purge condition and the duration of incarceration and modify any prior orders. They have to prove it. You have the right to remain silent. Let them prove it. So this is Florida, right? I don't live in Florida. Someone contacted me and said, hey, look, this is what I have. I'm like, all right. I'm not familiar with Florida's laws. I'm familiar with the laws in my state somewhat. So I'm like, all right. So I just typed in what they got, looked it up. And I'm like, okay, well, here, this is your defense right here. They want you to give them evidence to use against you. Don't do it. And you got to file as much. You got to tell them, but anything that they send you, just look at the rules. You saw in my other videos, just look up what rules they're using against you. Look up what they're trying to do. All right, I'm gonna continue this with another video, another of the same type, but a different way, a different one. If you want to check that one out, all right, and y'all can hit me up on my email if you have questions. I want to take a look at different ones from different states. So, all right.